All right, now for the top billing, it's Scott Robbins. He's an estate planning attorney with Barron, Rosenberg, Mayoris, and Mayoris right here in Troy. And he's going to talk to you again about all the tools in the estate planning toolkit that you will need. And we will have time for questions at the end. So welcome, Scott.
Well, my name is Scott Robbins, and I'm an estate planning attorney, but I also specialize in elder planning. And it really causes me and forces me to look at a lot of different things in a different light. So I'm going to try and be as general as possible and talk in the same direction that Jill was speaking, but my perspective on a few of these things might be a little bit different because I do deal a lot with elder law issues, Medicaid, veterans planning, and special needs planning. If you do want any more information about me or my firm, I do have a bunch of folders on the back table with business cards and then another brochure just filling you in with a little bit of information about some of the veterans planning that we do. Anybody's free to take some of the information, call me if you have questions, and I think after I'm done sharing some of the information about what goes into putting a plan together, we'll answer some questions, and I'll also stick around to try and answer any more specific questions that anybody might have. So what I want to do is explain to you what documents typically go into the estate planning toolkit. And this is a general discussion. It's not going to be a perfect fit for everybody, but generally we've got documents that address both the living probate or trying to avoid that living probate, and then also some documents to address what happens if an individual passes away and how do we address all the concerns and make sure that we get as much control as somebody might want. The living probate is going to be addressed with powers of attorney. And I would agree with Jill. Those are the most important estate planning documents that an individual can have. Because during your lifetime, unfortunately, there's a very good chance, I actually think the statistic is about 70-30, that you will experience some type of debilitating event where you'll need additional levels of care or somebody to make decisions for you. So there's two documents that come into play and provide a huge, huge benefit. Those are healthcare powers of attorney, more formally called a patient advocate designation. A lot of people actually refer to this as a living will, although Michigan doesn't use that term anymore. And then a general durable power of attorney that deals with areas of personal matters and financial matters. Again, my perspective on these documents is a little bit different. And so when it comes to healthcare, we need a document that addresses a few different areas. We need an end-of-life decision maker, we need a day-to-day decision maker, and then we also need a mental health decision maker. And it's really important that the document address all three. Michigan's unique in this sense because if a document doesn't grant the authority to also make mental health decisions, the document is limited to just making medical treatment decisions. And there's a lot of overlap between the two. So it's really, really important that all these documents include the full spectrum of authority for the patient advocate. The general durable power of attorney is a document that you can appoint an individual to make decisions regarding financial matters and personal matters. So this is somebody that you would pick to pay bills, file tax returns, apply for Social Security, collect mail, do anything that's personally related. There's only a few things that an individual can't delegate to their agent. That's the ability to vote in an election, the ability to sign a will on somebody else's behalf, and the ability to marry you to somebody else, which is probably a good thing. Within all of these documents, they're created as durable powers of attorney, and that word has its own legal meaning. That means that it continues on, and the power that's granted extends beyond a person's incapacity. So you can designate somebody as an agent for you, and even if you become incapacitated, the person that you've appointed will still be able to continue to make decisions and act for you beyond that incapacity. I'm also of the opinion that to the extent you can make it possible, you should appoint people to make decisions for you right away. There's two different ways that you can make a power of attorney become effective. It can be either become effective upon your incapacity, and that's usually done when two doctors state you're not able to make your own decisions. The alternative would be once you sign the document. I like to pick people that my clients trust, and if they do trust them, which I hope everybody would always pick somebody in that vein, that the person that they've appointed be able to make decisions right away. Sometimes it's difficult for an individual to carry on their own affairs. Sometimes, if I'm on vacation and I'm not available to make decisions, on my behalf, or, handle certain financial matters, I want my agent to be able to act on my behalf. Another thing is that once I've become incapacitated, it's going to be really important for my agent to step in and start managing my affairs. So the last thing that I would really want is them to need to take me to a couple doctors and get doctor's notes supporting that I'm not able to manage before they're able to go to the bank and pay my bills and manage any other affairs that I've got. I think one of the biggest misconceptions that people have is that if you become incapacitated, your spouse will automatically have the authority to act on your behalf. That's not true. It doesn't matter how close the relationship is, whether you've been married a year or 60 years, whether you have, one child or many. Nobody has an automatic authority to make decisions for you once you become 18 years old. So to have a document is very, very important. Another important feature that I like to include within my documents is alternatives. Sometimes you pick somebody today who would make a great decision maker, and then sometime down the road, when it is time for them to act for you, they're not able to make those decisions for you. So they're either unwilling or they would be considered unavailable. And to have a backup or a backup of a backup is going to be really important. I always challenge my clients to say, give me more names, give me more names. The most that anybody's ever given me, I actually had somebody give me 15, but I always will tell them if they can give me 100 names and prioritize them, I'd be happy to put them in that list. Because if you run out of agents, then we're going to have to go to the court to get somebody appointed as a decision maker for you. And so these documents are really, really important. For healthcare purposes, we draft our documents a little bit differently. And I have to be upfront and honest, nobody can make decisions for you when it comes to healthcare decisions until you're unable to make your decisions. But for day-to-day care, you can appoint an individual and ask that they be a partner in your care. We see that as people age, they don't always make the most intelligent decisions, and we say that they're competent enough to make poor decisions. So what we'll do is we'll typically draft a power of attorney with healthcare provisions to say that when an individual appoints a patient advocate, you want them to be a partner in your care, and you want them to be able to help keep you out of trouble and make safe decisions. You want them to be able to speak with physicians or other medical personnel, and you want them to be able to receive all the information that they need to be informed and to be a part of the discussion and keep you out of trouble. One of the most important factors of that document is a HIPAA disclosure. If everybody isn't aware, HIPAA is a federal act that protects a person's personal healthcare information, and without the right language in a document, the person that you've appointed, or if it's a financial person, if they need to pay medical bills, those people aren't going to be able to receive the information in order to help you out. So a big component of those documents is to have language in there to make sure that if there's any protected healthcare information, they'll be able to receive anything that they need. Now, some benefits that I've come up with for durable powers of attorney, both for financial and for healthcare, is that you get the assurance of who your decision maker will be. When you pick your decision maker, you can also grant as much authority as you want. You can permit them to deal with things that sometimes a court might not be willing to extend in the terms of an agent's authority. If you think of a situation where you might become incapacitated and you need a judge to decide who is the best person to make decisions for you, the judge doesn't know your personal situation or the relationship and trust that you might have with the person that you would select as a decision maker. So they're going to tread very lightly in appointing an individual and granting them a wide range of authority. If you trust an individual and you do so wholeheartedly, you can appoint that individual or those individuals with as much authority as they need. And when it comes to some higher level estate planning techniques, such as veterans or Medicaid planning, sometimes we need the full authority to transfer assets out of a person's name. If a power of attorney doesn't have that specific language in it, then there isn't any authority on behalf of that agent to do so for you. And it's always going to require a request from a court without that language, or if you're in the situation of a guardianship or conservatorship, to handle those duties or make any of those types of transfers possible. So the documents that we would create or that you can create should always make sure to include as much authority as you want to extend to your agents. Another thing that you can actually do is you can grant your power of attorney or your agent the authority to create estate planning documents. Now, they can't create a will for you, but you can authorize them to create a trust on your behalf. And if you've made some indication of what your plan would be, they can complete the plan by connecting assets to a trust if you've created one. Another really important feature within a power of attorney is the ability to manage real estate. And we use a few different strategies when it comes to real estate, and I'll specifically talk to you about deeds and ladybird deeds a little bit further on. After we get through the living piece, we come to a few different documents. There's wills, there's trusts, there's other documents that go along with them, and then there's also guardianship designations that sometimes find their way into some of those other documents. The best way to understand how a trust works is to really think about the way that the probate process works. And as Jill explained, if an individual has an item of property in their name or an asset titled in their name individually, there isn't an automatic right for a family member or a spouse or anybody to go and take that asset and administer it and transfer it and do whatever they'd like to do with it. We have to go through this probate procedure. The probate procedure can either use a will or it can be intestate without that will. And so a trust tries to avoid that process by serving as a bucket that can hold on to your assets. I always draw examples or diagrams for my clients. So if you can imagine that there's a bucket following you around, that's what would be your trust. During your lifetime, that trust is an extension of you. It follows you everywhere you go. It's like your alter ego, your shadow following you around. It shares your identity, and it shares your social security number. So in terms of an identity, the trust is an extension of you. You don't have to file any separate tax returns or anything like that. That's the benefit of it. What you can do is you can link your assets to this bucket. And you do this in a number of different ways, either by changing ownership or designating beneficiaries or signing deeds. But you link all of your assets to this trust. Now, your trust follows you around as long as you live, and you'll appoint yourself the manager of this bucket, and you also make yourself the beneficiary of this bucket. So anything you've connected to this trust is used for your needs. But when you pass away, this bucket will actually separate from you. It gets its own identity. It gets its own tax ID number. And you'll appoint alternate individuals, just like in the powers of attorney. You'll appoint alternate individuals to take over and manage the assets that you've placed in that bucket. Because this bucket has a person to manage, because it has its own identity now, we don't find ourselves in that situation where an asset is titled individually in your name, where we need to go to a court to get it out of your name. And so that's how it avoids probate. When we decide whether or not to create a document of that type, it really depends on what it is we're trying to do. A lot of times people will say that they'd like to avoid the probate court. A trust is one of those ways. Beneficiary designations are another way. And the most important thing that I think to consider is who is going to receive those assets, and do they need some type of special protection? Would they be somebody who would manage the assets wise? If you've got people who are over the age of 18, they can inherit it either through the estate of the administration of an estate, through a probate process. They can receive it directly through a beneficiary designation, and they can even receive it directly through a trust distribution. But when you create this trust, you can actually have the assets stop over and stay there until the coast is clear and everything is safe. And what I mean by that is, again, proper management. So if you have somebody who's not the most responsible and they might have one great weekend with the assets that they receive, you can put any kind of protections you want. So the person that is managing the assets isn't the same person who is the beneficiary of those assets. And they can make sure that the money is used for appropriate things. For the individual's health, education, maintenance, and support. You can use it to pay for opportunities for gainful employment, down payment on a primary residence, those kinds of things. And then you can choose certain ages or certain times to distribute money out to them. If there's an issue where a beneficiary might have a creditor, you can direct money into a trust and protect those assets so that if there is a creditor who would otherwise have a claim against the assets of that beneficiary, that they're not taken by that creditor and that they're used for more appropriate purposes. If somebody was going through a divorce, you can make sure that the coast is clear and so the money isn't distributed not only to a beneficiary of yours, but their soon-to-be ex-spouse. If they were a recipient of public benefits, we can put language into that document to make sure that they don't lose their benefit or become disqualified from receiving them if they were planning on receiving them. And they can continue to receive that benefit that they rely upon, but also have their needs supplemented by the assets that you've designated through that trust. Another thing to consider is the family situation that you're dealing with when you put these documents together. Jill talked about a second marriage or a blended family situation, and I deal with that a lot, where there's concerns where if something were to happen to one of the spouses, that the surviving spouse, if they don't stay in close contact with the children or the beneficiaries, the intended beneficiaries of the spouse who passes first, that they might change the plan and disinherit the other side. And so what oftentimes we can do is not create one bucket for the two of us, but we can create two buckets, one each. We can connect each of our own assets to one of these buckets, and we can make sure that if anything happens to one of us, everything stays in the first to go's bucket for the benefit of the survivor, but that after we're both gone, each of us gets the ability to designate our beneficiaries and the assurance that those beneficiaries will receive those assets. And so it's a great tool to use. Now, I do like to keep things simple, and so I don't always use two trusts, or I don't always use one trust. A lot of times I'll talk to somebody and figure out what are their goals. If we have a situation where there are no impending lawsuits or creditors, if somebody's not expected to go through a divorce, if there aren't any public benefits that we're trying to protect, I'm okay with using beneficiary designations. And it's just really important to consider what those assets are and how they're going to be received by the beneficiaries, because the beneficiaries, or the assets, I should say, find the beneficiaries as they are. And so there's no automatic protection that we'd have around those assets. So it's always good to consider. Another thing that I always tell people tread with caution is when you add somebody onto an asset. And Jill talked a lot about how when you put somebody on an asset, it now becomes their asset, and it's up to them with what they want to do, or if they were to ever become sued, that would be considered an asset of theirs that could become subject to the creditor's reach. Now, it's also something that you want to keep in mind, gifting taxes, If you add an individual onto an asset of yours, whether it be a bank account or a piece of real estate, the value of that item now becomes split between a few people. And if you transfer that asset to an individual, it's considered a gift if you don't receive something back in return. For a lot of people, for the vast majority of us, there isn't an estate tax issue, which is very closely tied to that gift tax issue. So it's not a huge concern in that respect, at least not today. But from, again, the elder law perspective, it could become a problem when it comes to receiving a public benefit, specifically Medicaid. I deal with a lot of clients who need to receive a high level of care, and we encounter a lot of issues where somebody put a child or multiple children on a piece of real estate. They added children to bank accounts. They gifted money to provide for tuition and those kinds of things. And it's been done within the last few years, and now it becomes a problem where that individual is not able to receive benefits because unbeknownst to them, that transfer, or by adding somebody on of their primary goal to make the transfer upon their passing easy, disqualified them for some period of time to receive a public benefit, and it becomes a much, much larger issue. So I'm not saying that you should never do it, but always make sure that somebody's informing you of all the concerns so you can weigh the pros and cons and decide if it is a good idea or if it is the best idea. Along with a trust, I like to create a will. And the will, in this case, serves a different purpose. It's not designed to appoint somebody to take control of the assets and distribute them according to your wishes. It's really for a singular purpose. The will's there as a safety net. So when you create a trust, the second most important thing after creating it is funding it. And that's also a term of art. That refers to the process to link the assets that you've got to the trust. Because just like that basket reference, if you imagined it, the only things that we can carry around in our basket are the things that we've actually placed into the basket. If you walk around with an empty basket or you don't put anything in your trust, then when it comes time to manage and distribute everything, it'll just be an empty basket. We do that by designating the trust as the beneficiary and designating the trust as an owner of things. We can use deeds to connect assets to trust. But if we've missed something, if we've overlooked something, that's where the will would come in this plan. The will, essentially, and it is about 5 or so pages, says, I want this person to be my manager. Usually it's going to be the same person that you've chosen as your trustee. So it's all easy to kind of wrap your head around. This manager that I've got is instructed to take whatever I might have left behind, whatever fell through the cracks, whatever I forgot about, whatever I didn't have an opportunity to connect to my trust. And their sole responsibility is to transfer it to my trustee so it can rejoin all the assets in my trust and be administered consistent with my wishes that I've put in the trust. So we call that a pour-over will. It's designed to pour over those assets that you've left behind into the trust so everything can be administered according to that one plan. Again, the goal, we joke, is to use as kindling for a nice fire, but as Jill explained, you really need to turn it into the court if you do have a will of a deceased individual. One little piece of advice that I would say when it comes to recording documents with the court is always let somebody know where you've stashed this document. And that goes for all the documents, not just the will. But the first thing that I will ask somebody if I find out that there's an item that's been left in somebody's name is there a will and do you have it? It's not uncommon where somebody has no idea where the will is, and they will turn the house upside down looking for it, sometimes still not able to find it. A lot of times we can get a photocopy, but a photocopy is not quite as good. It requires a little bit different procedure if that's all that we've got. But usually we'll go to a probate court and ask if they have one on file, and a lot of the times they'll say no. It doesn't mean that there's not one at a probate court. It's just not at the probate court where they lived when they actually signed their will. And so usually we'll ask around in the Tri-County area to find out if there's one stashed away somewhere. I have found them, but I've also not found them. And I'm sure that there's situations where there's a will that's deposited in a probate court that I just wasn't able to reach. And if the individual who signed it hinted to somebody where they stashed it or where they needed to look, it would solve a lot of problems and it would save a whole lot of time and cost. So wherever you stash everything, make sure you tell somebody to go look there. When it comes to connecting things to your trust, one of the biggest assets that people own is real estate. And so what a lot of people will do is they will transfer their assets into a trust. But you can also transfer assets to people. And again, I would always caution you to do that immediately because once you give it away, you can't get it back. But a lot of people have been using a special type of a deed in a way that sort of makes it like a beneficiary designation, and it's called a ladybird deed. What it is, it's more formally or more properly called an enhanced life estate deed. Deeds come in many forms and many complications, and oftentimes they're complex, and I see things that I've never seen before on deeds. But the best way to think about it is that when you think of a deed by itself, typically it's from a seller to a buyer, from person A to person B. And it's a transfer of all of the ownership. What a ladybird deed is a special type of deed where person A, who would be the seller or the conveyor of that deed, the grantor, you should call them, transfers that property back to themselves, person A, for their lifetime. And they say that they can reside in this house or stay on this property as long as they choose to, for as long as they live. And they also have the ability to do anything they want to do with the property. They can sell it, they can subdivide it, they can lease it or mortgage it. They can do anything that they want to do. But if they haven't gotten rid of it upon their passing, then it's going to transfer to person B. So what that does is it keeps it in an individual's name and lets you do anything you want to do. And then when you pass away, it transfers to whoever person B is without the need to go through any kind of procedure. All you have to do is record their death certificate at the Register of Deeds in the county where the deed was recorded, and that property is essentially transferred. One of the strategies that we use is actually designating a trust as that person B. So if you want to have that additional control, you can designate a trust as the recipient upon a person's passing, and it'll go into that trust so the trustee can manage it, potentially sell it, and divide the proceeds. A benefit that I find to designating a trust as a beneficiary versus 5 siblings, let's say, as beneficiaries is that you put one person in charge to sell that piece of property instead of having 5 people all agree on a price, all sign a purchase agreement, all show up to a closing and sign all the paperwork to transfer that property when they decide that they want to sell it. The only other document that I really want to share with you is the guardianship designation document. And I don't know if anybody here has minor children or if you've got children who have minor children, but that's oftentimes one of the most one of the biggest triggers for clients that cause them to give me a call and say, hey, I need to create some documents. I've got some minor children that I'm really concerned about, who would make decisions for them in the event that I was unable to continue to care for them. And so a good document should not only indicate a primary agent or agents as guardians in the event that you're unable to care for minor children, but also some alternatives. It should also indicate if you do pick a group, a lot of times people will pick one or multiple siblings and their spouses or parents, is you should indicate whether or not you would want one or the other one to serve individually. So as an example, if I pick my sister and my brother-in-law as guardians for my minor children, and for whatever reason my sister is unavailable to act, would I still want my brother-in-law to serve as a guardian for my minor children? For me, the answer is yes. For a lot of clients that I have, the answer is, well, no. If my sister and my brother-in-law can't do it, or my sister can't do it, I wouldn't want my brother-in-law to do it individually. I would want maybe my spouse's sister and her husband, my other brother-in-law, to serve in that role. And then put alternatives in place. And again, you can make that list as long as you want. I had, 15 was the longest. It was the same client that picked 15 for the powers of attorney. Another good thing to put within those documents is information about the children. So I've had clients that put information in there about their wish that if they're unable to parent the minor children, that they want the guardian to try and be as local as possible. And they actually put that in there as a qualification for them being nominated. They said if person number 1 is willing to relocate and move into town, then I would want them to act. But if they're not going to be local, then I would want person number 2 or person number 3 to serve in that role. And then they also included information that their children liked karate, or they liked ballet, or they liked a whole myriad of activities, and the things that really made them happy and the things that really upset them. So the guardian is at least getting into it a little ahead of the game, so they'll know some of the how to manage those responsibilities that they are asked to handle. A couple other things that I always recommend that people consider is that whatever documents you've got, you provide those copies to your agents if you're comfortable with them knowing what their responsibilities might be. So if you've got powers of attorney, you can give them a copy of the document and let them know, hey, I've nominated you. You might need to act for me, or it's my wish that you would act for me. Here's a copy of the document in case you do need to act. If you don't give it to them, at least let them know where you've stashed it away. I always tell people to provide or keep a couple copies, maybe one in a safe place, another one in an alternate but also safe place. For healthcare powers of attorney, Michigan actually has a advanced directive registry where you can go online and upload a copy of those powers of attorney. And I believe if a doctor participates within that function, they can obtain a copy for the event that they need to look to somebody to make decisions for you. If you are going to serve as a fiduciary for somebody, fiduciaries do get paid for their time, and it's a reasonable fee based on what they're doing and how long it takes them to do it, what their expertise is in the field. I always tell people that if you're going to act as a fiduciary, keep track of your time. Even if you don't intend to serve as a fiduciary or intend to charge for your services as a fiduciary, keep track of your time. Because if it ends up being a much larger task than you had thought, or if family gives you a hard time, and you decide later that you do want to be compensated for your time, it's very, very difficult to go back and detail all the work that you've done and compensate yourself for that. So humor me and just keep track of the time that you spend doing that. I would recommend consulting an attorney for some of the more complex issues. It's not necessary to get an attorney involved in every circumstance, but keep in mind that a lot of these things, there is no dress rehearsal. The documents that you prepare, you have the opportunity to create them and modify them as long as you have the ability to create them and modify them. So the time to plan was always yesterday. Never procrastinate when you're putting these things together. And it's really important to make sure that they are correct and the way that you want them to be prior to needing them to be used. When it comes to estate taxes, I could talk a little bit about that. Most people don't have much of a concern when it comes to estate taxes. Back in 2000, I looked this up just before sharing this with you guys. Back in 2000, an individual was allowed to transfer $625,000 of assets to whomever, anybody and everybody. And that includes death benefits on life insurance. So sometimes a single life insurance policy will put you over the limit for estate taxes. That amount has changed over the years. It's grown, it's grown, it's grown. It actually decreased a little bit for a short period of time. And right now, in 2018, it's actually much, much larger than anybody had ever expected. It's not $5 million a piece, it's actually $10 million a piece. And adjusted for inflation, it comes to $11.18 million per person. That means a married couple can transfer a total of $22.36 million to their children, their friends, their family members, whomever they want.
So go ahead and win that lottery.
Go ahead and win the lottery.
Small lottery, not a real one.
Now, it doesn't mean that none of us are ever going to have an estate tax issue, because that number can change. And the number that you're allowed to transfer tax-free is determined by the year in which you pass away. I'm not planning on passing away in 2018, so I'm not really going to take the $22.36 million to heart for me, myself, and my spouse and myself, because I know that that number is going to be different. I hope that it continues to go up with inflation, but realistically, I wouldn't be surprised if it came down significantly. More likely than not, it'll probably still be higher than any amount that I'll be able to transfer to my beneficiaries. But don't totally write it off just because it's a very large number. Tied in with the estate tax allowance is the ability to gift during an individual year. And so right now, the amount that you can transfer to any one person is $15,000. So if you're a married couple, each of you can transfer $15,000 to one person, so jointly you can transfer $30,000, and if that person's married, you can transfer to that person and their spouse each $15,000. So a married couple to a married couple can actually transfer $60,000 free of estate tax, or free of gift tax, I should say. If you were to exceed the allowance that you're allowed to transfer free of tax, it doesn't necessarily mean that you have to pay a tax right away, but you're required to file a filing with the IRS and notify them that you've exceeded this allowance. Whatever you exceed that yearly allowance by, your estate tax allowance when you pass will get reduced by the amount that you exceeded during that year of the gift tax. So again, if I were to pass away in 2018 and I gifted $1,015,000 to somebody, I would have exceeded that allowance by $1 million. I can't transfer 11.18 anymore. I can only transfer 10.18. Still not a problem for me, unfortunately. But if I give $1,015,000 to somebody today, and I don't die until, say, 2080, I don't know how old that would make me, but I pass away in 2080, and for some reason or another, that limit is 3 million. My estate is now going to be reduced by the amount that I can transfer tax-free, by that million that I exceeded the gift tax allowance in 2018. So the 3 million that I'm allowed to pass now becomes 2 million. And by 2080, $2 million will probably buy me a mediocre dinner somewhere. So it's not something that a lot of people would be concerned about right now, but it's something to always keep in the back of your mind and have a basic understanding of how those numbers, the gift tax and the estate tax, are tied to one another. That's at least how it's tied together for now. And then that other thing to think about is, again, just because I deal with this all the time when it comes to elder law issues, is that when you transfer assets away, it could cause other problems, bigger problems than the gift tax concerns or the estate tax concerns or the probate avoidance concerns or the person that you've now made a joint owner in a potential issue on your assets. And so those are the things that I would recommend taking, really taking to heart and put together a good plan for yourself so all the decisions are made when the time comes.